Hello everybody, it's Rick. It is Saturday, the 23rd of November, 2024. If you need to contact me, here's how to contact me. If you want to exchange a gift or paperwork to challenge child support, please send emails to the following addresses. Always check your spam folder for my response, if I reply. If I feel I cannot help, I do not respond. Okay, you got the addresses there. Where have I been? Well, I've been working, actually, not at a 9-to-5 job. I've been working here. I've been helping people. I've focused on tackling people's problems personally. Obviously, it's more time consuming, so it involves a larger gift. I've been having pretty good success doing that. Let me see here. I've been tackling definitions. Like this guy here, this letter to let you know that on 5/28/24, the local child support agency terminated the child support services and closed the support case for the children listed below. This was in California. I was able to show that the definitions for employer and a couple other things do not apply to him, and that's what we did, because in California they have a government code and they have their own definition of an employer, and an employer basically involves the state. It's a public employer, not a private employer. Many employers are private. What do we got here? Got another guy here. Thank you. I won my case using your documents. Got a guy's driver's license back. Oops, this is a different case. My eyesight is shot. That's what happens when you get older. Driver's license back. And the case was disposed by the judge. So anyway, and also I got paperwork for the states. I've been focusing on state statutes, and I've made paperwork for that. I have many states. I don't have all 50 states. I have basically the states that I received emails from. So I have approximately 17 states, but I can easily fashion them to somebody else's child support case in their state. All the laws are pretty uniform. Every state has its own uniform Interstate Family Support Act. All of the definitions are all the same in all 50 states. All 50 states have basically the same rules of evidence. I've been doing a lot of focusing on that. What else? Judicial notice, using the state's judicial notice codes or statutes, which some states use codes, some states use statutes, some states use laws, consolidated laws. They're all basically the same. Okay. And all of these laws, they're really contracts the way they're constructed. So to give you an example, when you get married and you get a marriage license, that state's law, you're basically agreeing to be under the state's domestic relations law, and that includes child support. So when you get married, you're agreeing to get child support. Okay, so marriage licenses are very bad. Any license. But today's society, they conned everybody into thinking that you have to have a marriage license to be married. And in a way they're right, because you want your spouse, your wife, or your husband to have access to your health insurance, life insurance, and also the statutes make it appear as though you must get a marriage license. It'll say you shall get a marriage license, and shall really means may, and must really means may. So the way they construct these statutes is they trick you. They basically coerce you into entering into this contract. A license is a contract. So when you get a marriage license, you're bound by all the excuse me, all the terms of that contract. And I've been, the last few months, basically, I'm at my desk here. I've been living in the statutes. Because I'm constructing paperwork specific to states and their state statutes. The states are bound by their own statutes. So if you're able to point out that they didn't comply with their own statutes, they didn't follow their own procedures, and in turn, you could also hold them to their statutes, laws, which is synonymous, like identity theft. Every state has basically its own version of identity theft laws, and what they're doing is they're representing you. They're taking you as a living man or woman who spells their names capital first letter and lowercase, first name and last name capital first letter. It's basically you're following the basics of English grammar. What they're doing is they're creating the old capital letter name, which is indicative of a artificial person, a corporation. That's why if you look up the state definitions in the Uniform Interstate Family Support Act, we'll call it UIFSA, okay? And it's a person is defined basically as a corporation, an individual. So again, when you agree to these contracts, you agree to their definitions. All right. So let me get over here. So and again, and anyway, if you're interested, if you have a case, especially if your case is just beginning, it's a lot easier to fight a case in the very beginning stages. A lot of people, the paperwork may not work for a lot of reasons. A lot of reasons are you've participated in the process. So when you participate in the process, whether you did it knowingly or not, you think that you're showing up to a court, and you think you have to, and then you find out you're complying with the process under duress, and then to them though you're supposed to know the law. So you're supposed to know that really the summons that you received, the way it was worded, is really an offer. Everything is an offer and acceptance, which is a contract. So you show up there, you start complying, you start answering questions, and what you're doing is your actions imply consent. Also, words, your testimony is valuable evidence for them, and it's witness testimony. So they can claim that your testimony was relevant evidence to establish a fact. So and sustain a judgment. So if you keep your mouth shut, you have the right to privacy. And your information, you don't have to give them your information. You could be polite, say, I'm sorry, sir, ma'am, I'm not going to participate in this process. And also, we'll look at these words right here. The claimant, plaintiff, is always bound to prove the case. So why would you help them prove their case? Again, you go there, you're taught or programmed your whole life that when you go to court, you have to answer the questions. And listen, I understand. I've had people, not want to participate, and then they had some maniac judges out there that they'll put you in jail. So I understand, it's just the process there is a lot more difficult because, you would have to go to higher courts to get it fixed. I had a guy in Ohio this happened to, and they, at this moment, we put in paperwork, and let's put it this way, the judge responded with a non-response. Basically, we let him know that what he did was illegal and unlawful because he had no proof that this guy was a consenting party to that contract. He was coerced to be there. He was there by fear. And he had a right to maintain his privacy, and he had a right to not answer any questions. So we're still dealing with that. But again, your testimony is valuable information to them. And again, and also, if you answer a question, your action is you're recognizing their authority. It's a big game. It's a big theater. The more you know your rights, the better prepared you could be going in. Touching on the rules of evidence, an affidavit is evidence. So what you would do is you submit affidavits, you get them notarized, you send it registered receipt mail to the clerk of the court, and then you bring that receipt with you to the court with the copy of the affidavit, and then you enter it on the record. And you could also say, I choose to remain silent. I'm just going to stand here and be a witness, because you can actually later on, what you can do is submit a witness statement, because by witnessing, no evidence being entered against you, no witness testimony verifying the evidence, there's actually no evidence on the record. So how are they going to prove facts without evidence? Well, they do it by presumptions, but we'll get to that in a second. So you can fight by saying you didn't follow the procedures. You didn't have any facts proven with evidence. There's no evidence. There's not a scintilla of evidence. And how are the facts proven? Okay. So anyway, let me move on because I'm getting off my trend of thought here. So there's a maxim of law, actor non probanti, and I think the last video I discussed this, but it's valuable because it's a principle of law. So what it means is that the plaintiff has the burden of claim. Now, again, I talked to you about these state laws of rules of evidence, and every state pretty much has a presumptive clause. And what the presumptive clause does is that if there's under their rules of evidence, there's a presumption that they use presumptions against you, and then it's on you to prove the presumptions. You got to submit rebuttal evidence to refute these presumptions. But what I do is I don't, going in with the state paperwork that I've constructed, is we demand to see proof that we waived our rights to our constitutional rights, and which is the Supreme Court. Where the hell is it? Waivers of constitutional rights not only must be voluntary, but must be knowing, intelligent acts done with sufficient awareness of the relevant circumstance and the consequences. So what are the consequences of you waiving your rights? So if you go, and I mentioned it in the last video, and it's sad because you're trying to do the right thing, but many guys, when you go to get, you're not provided access to your children, you're programmed to go to court to get custody. What you're doing is you're going to a child support court tribunal, and you're agreeing to access their services, which includes child support, by the way. So plenty of guys, and I don't mean to laugh, but I'm laughing because it's a trick. Many guys go there, and their intention is to get, shared custody, and next thing you know, they're getting an order to, they're asking all these questions, your income sources, your tax records, and everything. And what they're doing is they're compiling evidence on you, and then they issue the child support. So basically, they're coercing you to participate in this fraud. And I call it a fraud because you're going there with one intention, and they're like this, come right in here, and next thing you know, you're getting these orders, and these characters, they'll, make a finding of retroactive child support. The only thing with that is that you got to understand, you have to know about it. So if you don't know that you had a obligation to pay child support, how could it be willful? Okay. I believe in the last video I discussed that without proof of a contract, you have what's called a moral or natural obligation, which is not actionable in a civil court. So that's a defense right there. But they don't tell you that. That's the reason why they got to get you to imply consent, or go in and when you go there to sign a piece of paper for custody, you're acknowledging that you want something. Also, you have to do that with people, guys or girls. Well, girls, it's not girls, excuse me, guys, with the paternity, acknowledgement of paternity in these hospitals. And, a lot of guys don't realize that you're consenting to pay child support when you do that. Okay, but again, there's a way around that too, because it's a contract, and if they don't disclose the terms of the contract, you have to know everything in the contract, or the contract is void. Also, hey, a lot of guys, when they find out they're going to be a father, they have a few drinks. Maybe you had a few drinks that day, and you weren't competent because you were not in the right mind. Anyway, so we're going to show some slides here. Pause it. Right? Oh, yeah. What was I talking about? The contracts before. Competent parties. Competent parties refers to individuals who are legally capable of entering into a contract. This typically means that the parties must be legal age, sound mind, and not under the influence of drugs or alcohol. Now, I'm not saying anything here, but hey, maybe you did have a couple of drinks when you signed that paternity thing because you were feeling good about the birth of your child. That's, I'm not telling you what to do, but, many of you may have been in that position. You didn't realize it. Okay? All right, so let me start with the first slide. And again, I don't want to do a 40-minute video. All right, so I'm going to not talk. I'm just going to stop talking here, and I'm going to let you could pause and read it. This is a good slide, and I admit it. I probably talked about it last video, but this is why you have to object. The best way to object is with paperwork. Okay, And if you think you're going to go into these courts and just say, I do not consent, it's not going to work. Okay? There's ways to do it. You do it with the paperwork. And if you do it the way I say to do it, registered mail, you bring it to court. And then, I was saying earlier, then you can enter it. You can bring copies of the affidavits with the, what I have people do is they write the registered receipt number on the front page of the affidavit, and you can bring it to court, and you can enter it into evidence. And again, I like to enter into the evidence affidavit that I submitted on such and such date, and this receipt here is proof that you received it. So now it's relevant evidence to sustain a fact or establish a fact that I responded. And with the affidavits, you're asking for a few things. Okay. Also, if you don't show up, it's admitted by silence that everything is true. So that's the reason why you have to show up. But if you show up under duress, you're not there under a general appearance. You're there by what they call special appearance. But you're there under duress, so you're not there voluntarily. Okay? This is basically what I just said. Evidence. This is what I was just talking about. Okay. Right, this is what I said before. A confession made in court is of greater effect than any proof. Okay. Now, I was talking about the presumptions. This is a Florida statute for under their rules of evidence. And again, because I've been doing this and I've been basically, living in them, they're all basically worded the same. So I know it applies in every state. Okay. So again, here what it says: a presumption affecting the burden of producing evidence and requiring the trier of fact, which is the fact finder, which is the hearing officer, the commissioner, the friend of the court, the support magistrate, those people, to assume the existence of a presumed fact. Because again, this is all expedited. They don't have time. They got to get you on child support as soon as possible. So they don't have all this time for facts and evidence. Facts proven with evidence. So they're just going to use these codes of evidence, statutes of evidence, court rules of evidence. It depends on the state. Okay. So again, a presumption affecting the burden of proof that imposes upon the party against whom it operates. The burden of proof concerning the non-existence of the presumed fact. Okay. So read this slowly, right? Here so what let me do here. Watch this. I have Grammarly. Now, a little advice on these AI things. They're not going to write things for you. The best way to do it is you write it, and then you just check the grammar and stuff, because they will change words around. And trust me, that's what happens. Let me see here. So watch what I do here. I figured why I'm doing it. I do this all the time. Oh, I got it. Took me like four times. What is the meaning and intention of this statement? The statement explains a legal principle known as presumption. In this context, a principle favors a specific fact, meaning that it is accepted as true unless proven otherwise. Okay, the party opposing the presumption, typically the defendant, must present evidence to demonstrate that the presumed fact is false. See what they did? So they reverse the burden of proof. But what if there's no evidence that you voluntarily waived your constitutional rights to enter into a contract with the state? Because remember, you have a right to privacy. they're presuming that because you live inside this state that all of their laws apply to you. But it only applies to artificial persons, legal entities. You're not a legal entity. You're not artificial. You're living. So that's what I do in my paperwork. And so again, if so long as I'm not participating in their codes of evidence, now I can use the codes of evidence against them because the codes of evidence apply to them, but it doesn't apply to us because what I'm doing is I'm not agreeing that these laws apply to me because they're all contracts. Okay? Right, statutes, acts, and codes apply only to corporations and their agents and employees. So again, you have a right to privacy. Okay? And I was talking to you about these hearing officers. They have to, one of their famous ploys is you show up, oh yeah, your paperwork's dismissed. Oh, based on what? They don't have the authority to verbally dismiss or deny evidence. So all you got to do is, like this is Texas Family Code 202.002. There's nothing in here that says they can dismiss your paperwork. Again, your paperwork is evidence. So if they're dismissing your paperwork, they're dismissing your evidence. Think about that. You're providing evidence in your defense, and they're dismissing it. So in other words, they're not looking at it. So what they're doing is they're giving you an offer because they don't have authority. They're saying, I'm dismissing your evidence. Excuse me, I'm rejecting your offer to dismiss my evidence. Okay? I'm not accepting it. Because remember, it's an offer and acceptance. You don't have to accept it. All right? This is Washington. And they're all basically the same. This is the famous New York where I'm from. These maniacs. Okay, so all right, so I'm going to end this video, but here I got some information. You might have to. These are all the child support directors. I got access to. Last year I got access to them, and then I was about to. I think I mentioned it on a video. And that Friday, I had no access to it anymore. They removed it off the internet. Okay, so these trust me, they monitor these videos. All right, here are the state child support directors. Right, this is them here. Here we go. State child support enforcement agencies. Again, freeze it. Look at it. This is for every state. Okay. And again, here, if you want to contact me. And what I was talking about, personally doing paperwork, let's say you want me to do it for you for your state, it's a little higher gift. Okay, my gifts are usually under $200 gift. This is a little higher. It's not crazy. It's not like these other people that they're. I'm on TikTok, but not for child support. It's just for like a little fun information. I post my cats on there and stuff. But I see these videos, and it's hilarious. All these experts, but I've seen a couple of guys come up pushing their paperwork. One guy, he wants $1,000. He has a $10,000 package. Another guy is 100% using my paperwork, or at least some of my paperwork, because I checked it out, and he's basically word for word using my clerk paperwork and stuff. So I'm still a good deal. Let's put it that way. And again, I'm not looking to get rich. This is a kind of a passion of mine. I had a 2 or 3 year period where I wasn't available as much because I had health issues. I'm feeling great now. Everything's fine. I'm on my computer almost 7 days a week. I do between 3 to 5 hours a day. And again, doing paperwork for people is time consuming. So that's another reason why I haven't done any videos. Okay, I made a video a month ago and it froze and I lost the information and I had to get a new computer. So anyway, all right, guys. Hopefully I'll be on here. So I'm not making any guarantees, but I do intend to get back here soon. But I'm hoping this helps people. If not, have a happy Thanksgiving, and hopefully I'll be on here before Christmas. But if not, Merry Christmas. Bye.